Hello, everyone. Thank you all for joining this webinar. My name is Ed Garlepp. I'm here with my colleague, Samir Gokhale, to discuss recent developments in AI and IP law. Samir and I are partners in Oblon's electrical mechanical group in the Alexandria, Virginia office. We're part of the AI team here at Oblon. The main team members you can see in the next slide here. Here, next slide.
Oh, sorry.
So here are the primary team members. It's a good-sized team. We're all interested in AI technology, and we all work with Oblon clients to provide advice on AI matters. Our contact information is here. Feel free to reach out to any one of us. In addition, we all contribute to Oblon's AI patent blog. As you can see here, there's a view of the front page of the patent blog, and we're contributors, and I guess I should mention that Samir is not only a primary contributor, but he actually launched the blog, and he maintains it, does a great job of keeping our clients and colleagues abreast of AI issues. You can see in this slide that we also contribute to other blogs and even technical publications, and so keep an eye out for some of our articles across these publications. And now, periodically, we also do these webinars to keep our colleagues and clients abreast of AI issues. And we thought that it's about time that we did one of these webinars. So at this point, I'll turn it over to Samir to start off with an explanation of some background AI concepts. I guess what I'll do is I'll kick it off by asking you, Samir, the difficult question: what exactly is AI?
Thank you, Ed. Yeah, we've been giving these presentations for a while. It feels like 10 years now. I think when I first started doing this, this is the cutting edge technology of neural networks, and some of the deep learning advancements had just started, and we had to kind of teach the attorneys in our firm and some of our clients kind of what's actually happening. And so we had to say, hey, AI is on the rise, and we had to sort of define what it is. And it came with this definition kind of borrowed from different sources, and I like it because it sort of captures different features and doesn't commit to one thing. So artificial intelligence can be described as intelligence demonstrated by machines, in contrast to the natural intelligence displayed by humans and other animals or creatures. And some of the characteristics of an AI innovation is its ability to perform some kind of a monitoring or sensing function, a learning function, or maybe do some object or pattern recognition, make some decisions based on the sense data or the sense pattern, and take some kind of action. Now, not all patentable inventions or innovations have all of these features. Some of them do. Maybe something like automated driving might capture all of these features, but some might just be kind of the smart sensors, that are placed around our network. And what we've seen over the years is that while there's kind of a broad definition of AI, it actually starts to break down into component technologies in industry. And recently this summer, the USPTO did a helpful study on different AI component technologies that you can see on the screen. And they want to track, what are people filing at the patent office. And the next slide shows sort of the volume of AI patent applications by AI component. Kind of the leading one on that list is called planning, control, and knowledge processing. That's sort of the ability of machines to process information intelligently. So it's a pretty broad category, and it captures a lot of the neural network and sort of decision-making technology that is coming out. And this graph is also from the same report by the PTO, and I have a link on the slide. But it helps to also kind of see, kind of a more vivid spectrum of the AI innovations that we've seen over the years. And from a patent practitioner's perspective, each one sort of represents a different degree of difficulty in getting over certain hurdles before the patent office. I think in the U.S. system, kind of the big hurdle is patent subject matter eligibility. And on the screen, you see an example of neural networks, factory automation advancements, personalized content, and kind of on the rise now is AI hardware in the form of AI chips. And I think, you'll see throughout the presentation, we'll talk about sort of the challenges that relate to these different kinds of technology and what we've seen in some of the case law over time. So one of the reasons why I wanted to have this webinar is to sort of address the current state of play. I think, there's a lot of panels all over the country, even at the USPTO, they're always kind of reassessing where AI stands, what industry leaders are concerned about. I think the problem, though, is if you're looking at intellectual property law with respect to AI technology, it doesn't really change at a very macro level, meaning, you're not going to get specific legislation coming out of the U.S. Congress that directly addresses, something patentable related to AI. Usually there's broad laws that are designed to cover many forms of technology, maybe computer software, but nothing that really specifies sort of the challenge in AI. So what we end up doing is we look at case law and patent office guidance as sort of our key ways to see how it's being treated at the patent office and how it's being treated by the courts. So one of the big questions that's been talked about the past few years is this concept of AI as an inventor. Now, it may not be a particularly useful topic in terms of what we actually see in industry, but it's a pretty hot topic sort of existentially or at a kind of a interesting creative level. And Ed, I think you have some knowledge on this topic. You want me to give some background about what's been going on with that?
Yeah, sure. Sure. Thanks, Samir. Yeah, it is an interesting area of AI patent law because there actually is case law that has been evolving over the past few years. And it all started out with an AI inventor, Dr. Stephen Thaler, who decided he was going to file a bunch of test patent applications and name the inventor as a particular AI machine called Dabus maybe. So Dr. Thaler did that across many jurisdictions, and these cases have been working their way through the court. And the Federal Circuit recently chimed in on the issue and decided rather definitively, that's just a couple months ago, that an AI cannot, in fact, be named as an inventor. And the analysis is basically the words of the Patent Act, the U.S. Patent Act. The Federal Circuit took a look at the language, for example, the term individual, and decided that the Patent Act intends an individual to be a natural person. And so the ultimate holding is that an AI machine cannot be an inventor. I guess I'd ask you a quick question, Samir. What do you think about the possibility that the Supreme Court might chime in on this issue?
I would guess it's not likely. Usually the Supreme Court weighs in on areas of conflict in the law. Maybe two different circuits are speaking differently about an issue, or there's sort of a gray area that urgently needs to be resolved with respect to constitutional law. I think if there's a consensus on the issue and the Fed Circuit is sort of the dominant sort of court below the Supreme Court that already weighed in on it, unless there's some push to get it in front of the Supreme Court. I don't see it happening, in my opinion, but who knows? Maybe it'll pick up some steam and they'll take a look at it if the Davis party actually decides to go that far. Just one quick note before you go to the next slide. If anyone has a question, you can put your question in the Q&A box that's on your interface for the webinar. And at the end of the presentation, Ed and I will try to get to as many questions as possible.
No, I agree with you. I think it's unlikely that the Supreme Court will take up this issue. I think it's at least it seems fairly settled from their opinion. And as we see in the next slide, in fact, most of the patent jurisdictions around the world agree with the Federal Circuit. As I mentioned earlier, these test cases were filed in many different jurisdictions, UK courts, the EPO courts, Australia, German, have all declined to allow a patent issued to an AI, that is Davis. I believe all of these jurisdictions were part of the test. There's one exception here, and that's the South African court that did, in fact, name, issue a patent which named the Davis, as an inventor. So one thing to note here is that it's a registration, system. It's not a substantive patent examination system. So we see there is a consensus that is sort of developing around the world that, software-driven machines are not a natural person as required by most patent laws, and so they can't be inventors. But the nature of an AI as a software-driven machine raises another issue in patent law, and that is subject matter eligibility, which many of us are familiar with the evolving case law over the last decade with respect to run-of-the-mill type software inventions. So I guess I'll ask you, Samir, what does the Patent Office and or the U.S. courts, what do they have to say about subject matter eligibility with respect to AI inventions?
Yeah, thanks, Ed. Yeah, I think that when we look to kind of guidance on how to treat AI, for patent law, subject matter eligibility has been something that, we desperately needed for a long time. It kind of fits into two categories that make it vulnerable. Well, two of many, I should say. One is it's software mainly, and a lot of software inventions got sort of scooped under the bus when Alice versus CLS Bank came out. And it's also a technology that is sort of designed to mimic human activity. And, a very broad claim to an AI invention could literally look like human activity, which is a big red flag before the USPTO with regard to subject matter eligibility. So, without specific case law, sort of specific congressional action taking place, and a lot of AI cases not making its way up to the Fed Circuit, the PTO has created these subject matter eligibility examples to kind of help examiners understand what should be considered an abstract idea and what shouldn't be, or what should be able to be patent eligible even if it has an abstract idea included in it. And they had this example 39, method for training a neural network for facial detection. It's a pretty broad claim if you look at the example, and it just is describing sort of general steps for training a neural network, to sort of update it based on factors in an image for facial detection. And they said, okay, this is not, this is under prong one. I mean, there's no judicial exception at all in this claim. There's no math. It doesn't really address the mental process, and it's not really related to a method of organizing human activity. So this is kind of signaling examiners, if you have a claim that's directed to a method of training a neural network, it shouldn't even get, past the prong one question on whether or not it covers any of those judicial exceptions. This USPTO guidance sort of made a safe harbor for neural networks and training neural networks. And then, they also had another situation where they had a PTAB appeal, sort of the appeal boards before the USPTO. It's called Ex parte Linden at some point. Now it's called Ex parte Hannon. And it's not precedential. I mean, it's not Fed Circuit level decision. but they called it informative. The USPTO went out of its way to label this case informative. The claims were directed to a method of using a trained neural network to transcribe inputted speech. So it was a form of speech recognition AI. And the PTAB reversed the examiner's finding that the claims were not eligible under 35 U.S.C. 101. One of the things they said is that, they kind of compared the human process of transcription to the different techniques that have been used by the AI for sort of normalizing the input file, generating audio files. And the kind of the key, I think, there was they obtained predicted character probabilities from a trained neural network, and then they did the decoding and transcription of the inputted audio. And they said these steps cannot practically be performed mentally. And so again, you have a case with a trained neural network involved, where they said this is not a mental process. And this case was significant because, many AI innovations are really attempting to automate a mental process in some way, shape, or form, or a human activity. And this decision sort of helped clarify, that the specific technical steps of the claim are what should differentiate the invention from an actual mental process or human activity. In this case, a human doing speech transcription versus a computer doing speech transcription. So we sort of created this safe harbor based on these two examples of, using neural networks or training neural networks. They shouldn't be considered the same as a mental process or a mathematical concept. But that's the USPTO guidance on that topic. Another case that we saw this past year, or I should say December 2021, was Health Discovery Corp versus Intel Corp. This case was interesting, and it's at the district court level, so it wasn't precedential, was that you have this technology. It's called support vector machine recursive feature elimination. It finds relevant patterns in large data sets, such as the data generated in sequencing genomes, and outputted, sort of a more distinct subset that was full of the useful information that the user is looking for. And this took place in the Western District of Texas. It's Judge Albright's district. He's famous for being friendly to patent owners, and so he actually found this not patent eligible. He said that the patent claim, it's just enhancing the abstract idea. In his opinion, the claim should have been drafted as something, some improvement tied to the physical, not improvement to the abstract idea itself or mathematical method. And one of the takeaways I took from this case is that, when the court saw the facts of this case, it saw this technology as basically taking trained data to train the machine to filter data, and then they sent live data into the machine to sort of, in sort of the using portion of a neural network or a machine learning algorithm. And it's kind of the nuts and bolts of what we kind of consider to be the black box without really any physical components in it, and really no practical applications. Explicitly recited in the claim that didn't actually mention anything about genomes in the claim itself, at least the one in one of the broader claims that they had. And the court just saw that as math. So if you have kind of bare algorithm language in your claim, there's a chance that you could be treated just as like a mathematical method or something not tied to the physical. This case almost made it to the Fed Circuit. It was appealed, but then they withdrew the appeal to kind of try the case again in different avenues. And I think it's kind of going through kind of a dual process through the PTAB and the district court still. But it's a case to watch, because if it actually does go to the Fed Circuit, we're going to get a lot of opinion type language on AI technology. Okay. And besides 101, I think another big subset of the law that affects AI is the written description requirement under 35 U.S.C. 112A. And I know that Ed has given us some great blog posts on this exact topic, so I'll turn it back to Ed so you can kind of shed some light on why this is such a big deal.
Thanks, Amir. Written description, it is an area to keep an eye out for when dealing with AI inventions. As we saw from the earlier slide, we're sort of at the front end, or maybe in the midst of an AI patent boom, sort of. And I guess early on in the AI patent boom, some policymakers and legal scholars questioned whether the current law under 112A previously first paragraph, was adequate for handling AI inventions. But the PTO and legislature has essentially generally taken the position that the existing framework of 112A is adequate for handling all technologies, including AI. So, as with the other areas we mentioned earlier, there's no change in U.S. statute or regulations that's on the horizon, and it's left to the case law to sort of sort out what is an adequate written description for an AI invention. And here we see the text of 112A. We know there are a few requirements. We'll focus on written description here. And, the general standard that has evolved under 112A in the courts is that the specification has to describe the claimed invention in such a way to demonstrate that the inventor, quote, had possession of the claimed invention at the time of filing. That's sort of the key word there. And so one takeaway, and this is explicitly stated in some cases, it's not enough to indicate the result of your invention. That's not enough to demonstrate that the inventor had possession of the invention. And that sort of relates to AI, and we'll talk a little more about that in a minute. In the next slide, we see that the courts have also taught us that the level of detail of the written description, the detail that is required, depends on the scope of the claims, in part on the scope of the claims, and also the complexity or predictability of the technology. And we see here two Federal Circuit cases that come down on both sides of the issue. Mechanical invention, the Federal Circuit said, what would be considered a brief written description was enough to satisfy, a brief specification, I'd say, enough to satisfy the written description requirement. But in the software technology, in the second case here, the Federal Circuit reached the opposite conclusion, perhaps because it's not such a predictable technology. So how might these legal principles be applied to AI? As we see in the next slide, let's just take a look at a brief look at a broad hypothetical AI claim. This is quite a broad claim. It's essentially a genus claim that's directed to AI or machine learning. And so the breadth of the claim itself and the predictability of technology, because AI is in its infancy, would suggest that the written description for this claim should be detailed in order to satisfy 112A. And the case law has stated that you have to disclose a representative number of species in order to satisfy the written description requirement. Given the breadth of the claim and the unpredictability, so to speak, of AI inventions, for this type of claim, you would want to be quite thorough in your written description requirement, just in your written description, to make sure you meet the requirements of 112A. And in our next slide, we take a step back and sort of look at why is AI considered to be an unpredictable technology. And I think it's useful to think about two categories of AI. One category of AI technology I'll call the training algorithm. this is sort of the stuff that has been the subject of academia for many decades. You know, complex mathematical functions, you know, step-by-step training steps, how to actually train a system to be useful in a particular problem domain. The other category I would call, you know, applied AI, and this relates to the post-training model, what we call the model that results after you train the algorithm. And here, I think, is where this notion of a black box comes from. When you train an AI algorithm to be a model, what happens is the system iteratively goes through many different possibilities of correlating particular input features to possible output predictions. And what happens is, after a massive number of iterations, the system generates a statistical model that defines correlations between input features and outputs. Now that model can be deployed without sample data, but with real-life data, and it's fairly useful in predicting the outcome. The problem is the massive number of iterations that take place and the complexity of the data structure are such that nobody really can wrap their brain around it, and that's why it's called a black box. And so this raised the issue of, well, how can we describe what's in here if we can't actually understand it? And so in the next slide, we'll take a look at some practice tips on how to deal with this. So one thing to keep in mind when you're trying to describe AI inventions, much like the algorithm versus the model, we categorize the inventions as core inventions, generally directed to the algorithm or machine learning concepts themselves, and applied inventions. These are the models that, after they're trained and you know, and useful in a particular problem domain. For core inventions, you want to focus your description on those principles of academia that I mentioned earlier. You know, the complex mathematical functions, the training steps, maybe the you know, the network topology of the neural network. That should be your focus. The actual results or very granular training steps and tuning parameters is probably not as important, although it shouldn't be neglected. For applied inventions, again, this is the model that's deployed in a specific problem domain. Here we have the black box problem, and so it's very difficult to describe the end model or statistical model. It's just too complex. So here the focus of the description should be very much in the sorting of the initial data, the definition of the input features in that sample data, possibly some known correlations between the input data and the output data even before the model is trained. And then finally, I would say training of an AI system is itself pretty iterative and trial and error. There are a lot of manual tweaks of hyperparameters of the algorithm that take place, and that process of training the model, it actually yields some knowledge to the trainer. And I would say whatever knowledge you acquire from this process, you should probably try to include that in the written description as well to make sure you satisfy 112A. And so I know we're running very short of time, but we talked about a couple of patent law areas. I guess I'll kick it back to you, Samir, and ask you, do you know of any other areas where patent inventors or professionals need to be cautious of in developing AI technology?
Yeah, thanks, Ed. I think one thing I've seen, and I've been involved in some panels the last couple of years, where the idea of protecting data has become a big talking point. We talked about sort of that applied invention perspective, where you don't really, invent the black box, but you're going to use it for something very specific to your company's needs. And sometimes that involves a heavy investment in collecting data from the public, from certain areas where the data is important to you, and then utilizing that to get some kind of an AI that's smart in the area you need it to be. So you collect a lot of data, maybe it's through the Internet of Things, like shown in this graphic, and you create your model, and then this data, what do you do with it? How do you protect that as an IP asset? And that's been a big question in the last couple of years. We talk about the neural network. It's what's inside that black box. You can't really describe. It's very hard to obtain patent protection on something like that. It's basically a data structure, and it's very unique in itself too. There's probably a chance you could put training data a million times, you won't get the same neural network twice. And then you have trade secret protection. That is probably a preferable method if you're sort of at the server level, that kind of company where that doesn't make it down to the consumer device, and you can hide that data structure for as long as you can. So companies will invest a lot of resources, to train that neural network, and then they have to decide, how do you protect that data that basically made your AI, very accurate or very competitive in your field. When we talk about protecting data, there's been some discussion of the non-patent methods, as we mentioned, trade secret protection. To kind of boil it down, that's preferable when something like patents doesn't work. Those types of IP protection aren't available. Maybe this is too expensive to try to get a patent, or you need to hold on to that secret for longer than the 20-year term that a patent may offer you. Copyright protection, it's a very narrow form of protection, especially in the U.S. It protects the selection and arrangement of material in a database where it's original or creative. And so your actual selection or arrangement of whatever that data is in the database has to be done with some kind of creativity. And that's not really a point, in terms of trying to ward off, copycats or infringers. But one thing that has started to rise, and it's been available for a while in Europe, is this idea of sui generis database rights. And I probably butchered that phrase, so forgive me for that. But what it is sort of a separate class of protection itself. The databases, if significant investments have been made to obtain or verify their contents. It's available under kind of the general EU countries, I think, plus the UK as well, but not the US. So I don't think any congressional action will sort of is on the horizon to cause that to change. But people are talking about this because there's so much investment in this data, and if you can't protect it, basically you can lose a lot of a lot of that investment money. One more topic that we probably haven't talked enough about in some of these panels that I'm on is the idea of AI hardware. Basically, the AI chips in the semiconductor industry is building chips just designed for AI, and they're on the rise. They have different abilities that perform certain ways based on the AI algorithms. They can do certain forms of parallel processing. There's a whole list on the screen. I'm not going to go over them all. But what are the patent issues to watch in that kind of a technology where it's mainly structural and sort of built off a legacy technology? So some issues that we've seen in these areas are trying to avoid obvious system infringement from legacy chip patents. We saw this with LTE, where something from the WiMAX working groups actually would be used as a reference, or some inventors from those times end up being people who would sue the people who make some of the technology. And because it's an AI chip, you want to be careful to avoid the intended use features. Maybe it's it's mainly structural, but it's being used for AI. Well, that might not get you patentable way before the patent office in many situations. So you have to be, mindful of how you claim these sort of in the context of AI, without sort of, crossing that line into intended use. And also, I've seen some of the patents out there that have a mixture of structure and functional features, and sort of like the way that they process data might be different in addition to the structure. And I think you have to be careful in those situations where you have functional claiming involved, is you still pay attention to kind of what can trip people up in terms of triggering something like 35 USC 112F, where you're considered a functional claim and you may have overly narrowed the scope of your patent because you did that. So those are the issues to watch in AI chips. We'll probably dive into that in a future blog post. But those are the issues that we've seen in sort of this AI patent landscape and sort of, what's kind of caught our attention, especially in the past couple of years. I think we'll take a peek at some questions now, but our email addresses are on the screen. Let me see if anyone's asking any questions. Well, we did such a good job, Ed. I don't see any questions. But yeah, if you have any questions, you can always email us, and we'd be happy to help you. And yeah, we definitely enjoyed giving this presentation to you today.
Yeah. Thank you. Thank you very much.
All right. I think our marketing department would appreciate if I say you can find both me and Ed on LinkedIn, and we love it when people watch our webinars and then get connected to us later. But thank you for your time today, and yeah, have a good rest of your day.
Thanks. Have a good day.
Thanks, Ed.
Thanks, man.